Afternoon again, Tabana, and thanks for being kind with your rendition. Good afternoon, everyone, and welcome to session 7. Can you hear me? Hello?
Yeah, we see.
Okay.
Yeah.
Okay, the internet seems unstable here. If it continues, I would lose my video just to improve the network. So welcome again to session 7 of the 16-day introductory training on energy law and policy for lawyers. I have 2 days, but for today, we'll be focusing on financing assets acquisition and development. And I should mention that my topic isn't sensitive to gas, but sensitive to upstream assets. Just to correct that. Now let's set the stage for today's conversation and discuss the context. I mean, typically when you hear asset financing or acquisition financing, it's possible to make that mistake of rushing to your loan agreement or rushing to your loan documentation. But that's really not the first thing you should be doing, because you really should seek to demystify the construct. What exactly is this all about? In acquisition financing, there is the asset selection itself. You have to identify the asset, and the process of identifying the asset involves, certain critical considerations. After you've identified your asset, then you acquire your asset, and you may be acquiring. If you've got a deep pocket, you obviously may not need financing, but it's very rare, right, for projects in the upstream sector, to be financed solely based on equity. And then you then proceed to develop the asset. The choice of your asset is not a consideration that is limited to your thinking and choice alone, because if you're relying on the lender's pocket for this, then there are a number of key considerations. And the way we've set out these slides today is to speak to my learned colleagues, to let them realize that for you to be that trusted advisor, you should be able to identify the risk, assess the riskiness of the lender's investment decision. Even if you're acting for the buy side, the fact is you need to be able to sell a project that is investment ready. And that entails you understanding what the lender will be looking for, both at the acquisition stage and for development financing, or even for working capital. So in setting the stage and putting things in context, it's important to understand that lending is not a charitable business. The transaction has to be bankable. And when you have deficit in acquisitions, it's not because there's a shortage of capital. In most situations, it's not because there's no capital. And you would agree with me that a lot of times we say a lot of gas assets are not being financed, they're not being developed. We have stranded reserves. Nigeria is a gas-bearing nation, but nothing seems to be happening. It's not because we don't have gas in the reserves. It's probably because somebody has not put that deal together to make it bankable. So the task for you, whether on the buy side or acting for the lender, is to be able to identify what are these risks, what should I be solving for. Whether we like it or not, we need to appreciate the fact that it is quite capital intensive in the upstream sector. And if you do not cross or tick the box in the upstream sector, you really cannot be talking about the midstream or downstream space, right? The risks are arguably more in the upstream sector. And that's why you tend to find that pre-production financing or developmental financing is not attractive to financiers. So having set the stage, you would agree with me that in this kind of conversation, we shouldn't be talking about the loan agreement yet. Let's understand what we need to put together before we get to the loan documentation. I've spoken about the demystifying the construct. So packed in this topic, packed in that engagement is asset identification, at the acquisition and development of the asset itself. And the requirements for development will be influenced majorly, whether it's a brownfield, whether you've actually even developed the.
Yemisi, you're on mute, Yemisi. And they're also asking for your slides. Can you hear me, Yemisi? For some reason, you should try and unmute yourself. There's something wrong with your system. Wale, what's going on? Okay, go ahead. Yeah.
Okay, I've been muted now. When did you lose me? At what point did you lose me?
About 2 minutes ago.
Wow, okay. So let me just...
And then they're complaining about your slides.
They can't see it?
They can't see your slide now.
Wow. So just give me 2 minutes to check this. Can you see my slides now?
No, not yet.
Okay.
Was on much earlier before the session started, but
yes, can you just click on share screen?
Okay.
All right.
Okay. Can you see my slides now?
Double click on the slides.
click on a particular slide. Then
Can you see it now?
it's not open yet. So we're just seeing your inbox page.
Wow. Do you want me to send it to you to share?
Wale, can you share it if she sends it to you?
No problem.
Okay, send it to. Let me see. People like these slides a lot, so.
I had it on before. I don't know what happened
Yeah,
actually.
You did before we came on.
Wow. Please bear with me. Okay.
I was enjoying it without the slides, but quite a number of them are saying, "Oh, where are the slides? Where are the slides?" So.
Okay, so can they give us about 4 minutes to resolve this?
Yes, just go ahead. Go ahead.
Okay.
Let's see what we can do.
Okay. Don't have that email address. Wow.
There's activity on the screen, but still not showing your slide. Let me see if you can send it to me. I'll just send it to Wale, then you can continue, and then people will pick up from wherever they pick up. Yeah.
Okay. Okay. Let me send to you.
Don't know how you want to
Apologies, participants. Just a minor glitch. We'll be back on quickly.
Can you see it now?
No.
I guess I'd have to, let me just continue.
Yeah, continue, and then
Yes,
we'll,
I'd have
we'll
to
sort it
continue.
out from the back end. Yeah.
Okay. Tobina, can you speak to Munira? She'll send it to you, forward it to you.
All right.
So let me just continue. Okay.
Okay, continue. No.
Sincere apologies for this. I had this on earlier on. I don't know what happened. But okay, so going back to the point I made a few minutes ago on demystifying the construct. Packed in the asset acquisition conversation is asset selection itself, asset acquisition and financing, and the asset development. And the key point I'm seeking to pass across here is that if you want to be a trusted advisor, your starting point in this conversation should never be putting pen to paper in the loan agreement. It's starting from bankability of the transaction. Is your investment, is your dream, is your investment ready? Is your acquisition investment ready? If it's not investment ready, it means you have either not assessed the risk profiles at all, or you have assessed the risk profile, but you have not considered the risk mitigants. You have not considered the risk mitigant, you have not considered credit enhancements, and you have not put the lenders in a position where they can make that investment decision. So it's important that when you're getting into this, you understand what the lenders will be looking for. That is what makes the conversation easy, and for you to be able to achieve the objective of financing your asset. Now, starting with the very first component, you have the asset selection process. And what are the key considerations? What are the key considerations for asset selection? Now, across the value chain in the energy sector, we have the upstream asset, we have the downstream asset, we have the midstream asset. But depending on the time, we may not be able to cover the midstream and downstream asset. But for upstream asset, what are the key considerations in selecting your asset? And what are these assets really? So you have your concession, which it could be your oil mining lease or your oil prospecting license. And in addition to your oil mining lease and your oil prospecting license, you could have hard assets. And what do I mean by hard assets? In the contract area for your OML or your OPL, you may have processing, handling, evacuation, or storage facilities within the contract area or very close to your contract area, because you really cannot develop in vacuum. Those assets have to be identified. You would also have soft assets. And what do I mean by soft assets? Your revenue generating contracts. Because think about it, if we're financing, the most important thing for the lender is that it can follow the hydrocarbon or that product, it can follow it to the market, and it can realize cash flow to bank the deal. So within the package of your soft asset, you have your revenue generating contract, which typically would range from your crude offtake contract to your gas offtake contract and everything in between. And when I say everything in between, if you've processed your crude oil, you would have product. If you've processed your gas, you would have product. So you have a revenue generating contract for realizing cash flow. And then the operations contract, which could be your pipeline transportation contract, your, hello?
Let me see where we can hear you, but we can't see your image.
Your pipeline transportation contract, your evacuation and terminal, you could have your terminal services agreement, you could have storage contract. I mean, the point to note is that when you're considering the package for the asset, it goes beyond that concession. You look at everything together. And if it happens, it so happens that it's a greenfield where there has not been any development, then you don't expect to have existing revenue generating contract because you then want to make it happen. But for your brownfield asset acquisition, asset they're already producing and developed, when that seller is divesting of its asset, there'll be other things that come into that package. And then there's a question on the land itself. A lot of times there's that misconception or assumption that the fact that you have the concession, you also own the land, but there are considerations around land ownership. I mean, there's an acquisition we worked on recently where, you know, what the sellers were entitled to was a long lease of the land hosting the assets, right? And it was after the divestment that the community was ready to engage the new buyer on renewal of the long lease. So it's always nice to check, in fact, not nice, important and critical to know whether there is outright ownership or there's a long lease of the assets. The other considerations, do you have my slides now, Tobena?
Not yet, still trying to get money right, but it's fine. Just continue.
Okay. The other considerations for the lenders, right, which is important to the buyer as well, is interaction of the law with the asset type and the asset size. There's also the key question of due diligence in the asset. And what do you mean by due diligence in the asset? You want to know more about the asset that you're about to fund its acquisition. And due diligence has about 3 components. There's a legal due diligence, there's a technical due diligence, and the commercial due diligence. Now, focusing on legal due diligence, where do you really start? You start with title verification. That OML, that OPL that you want to acquire, does it belong to the sellers or not? How do you confirm that? You would typically do that at the Department of Petroleum Resources after being authorized by the sellers at a fee. You also want to find out about the good standing of the sellers. And good standing, you know, is quite a vague expression that means everything. Checking whether there's been compliance with obligations under the law. When you move away from title verification, the technical guys will want to check for reserve verification. Do we really have anything in situ? Do we have anything on the ground? Why should I lend to this hole, right? And in determining that, you have competent persons who would carry out a competent persons exercise in checking for the reserve, the quality of the reserves, and how much you've got in there. You also have reserve certification exercises. Now, if it's a developing asset, if it's a producing asset, there is this recurring annual obligation on a producer to file annual returns on its reserves. You can also get information from that. There's also the point about the life cycle of the asset. Now, if you're financing an asset that particularly is a brownfield, it's important that you're not lending to, because you have finite resources underground, right? It's not a renewable, we're not in the renewable energy space. So once you get to the reserve tail, you want to be sure that as you're structuring the repayment profile for the loan itself, you have a full understanding and appreciation of the reserve tail. There's also the point on access to the market. No matter how lucrative, how prolific your assets are, if there's no access to the market, if it's stranded, you need to consider the cost of evacuation and getting the products to the market. And this consideration also influences whether a lender is ready to wait for you to construct the asset, is just ready for an asset that, you know, it's quite close to in terms of logistics. You also would be checking legally for existing encumbrances. There are assets that are heavily encumbered. What do I mean? There are mortgages, you have charges on them, and you have to make that decision. Am I selling with the encumbrances, or am I going to be releasing this security interest before selling? Of course, everybody understands that when it's encumbered, it may not be attractive, and it changes the conversation. And also, you then go to community-related issues environmental claims, litigation, actual threatened, or even arbitration. Now, key question for the reserves. Let me try and share the screen again. It's a pity that you can't see my screen. Just let me know if you can see it now. So for the risk profile and reservoir risk, what exactly are we looking for? What do you need to understand that the lender is looking for in coming to that determination whether it would actually finance the deal? The nature of the recoverable hydrocarbons. And typically you would talk about proven reserves or probable and possible reserves. You could also talk about possible and contingent reserves. For the lender, particularly and we'll get to that when we're talking about the sources of funding. We're talking about reserve-based lending, for instance. The lender is interested in proven reserves where there's a 90% chance of recovery, or worst case scenario, probable and possible reserves where you have a 50% chance of recovery of the resources. And why is this important? If you're not able to ascertain the reserves, then you can't have production profile projections. You really cannot put a finger on the proposed production cost. You also cannot begin to determine what the field life would be, and this would affect your revenue generation capability and ability to service the debt. And also even for the equity financiers, how do they plot the graph for sustainable and attractive equity return? Operational risk. In a lot of the recent acquisitions going on here locally, it's always the conversation on who will operate the asset after the IOCs divest. And here I'm talking about the IOC divestment, not marginal fields here. The lender is concerned about operational risk. There's a point about proven technology. There's a concern around the operator's identity and track record. Does he have what it takes to actually continue to operate and improve upon the track record of a Shell or a Total or a Chevron, right? And that's quite important because it has an impact on your recovery rates. It has an impact on efficiency. It also has an impact even on liabilities, contingent liabilities, environmental pollution. If you have the wrong operator, you may run into trouble and it may just ruin, the good case that you have on an asset. So for the operational considerations, as you are plotting the graph, you're advising your buyer or you're speaking to your lenders, you need to also begin to think about who are we handing over this asset to? Do we need to have arrangements around technical services, field management services with a known and good hands if your buyer is not experienced and doesn't have the technical might that is required to be able to bank this? These are things you don't ignore, because if you ignore them, your financing is typically delayed. And if you're in a competitive bid process, you want to ensure that as you're submitting your offer is bankable. We move on to the next risk, which is also important to lenders, which is a price risk. I mean, we all understand, or we should know, that hydrocarbons are typically priced on the quality of the product and against the relevant benchmark. Price fluctuations, volatilities, they assess your ability to forecast your production, your cash flow, and the debt service profile. So it's very important from day one that you have a plan that you're working with, and that's why you typically would have hedging arrangement to mitigate the risk. So the first thing is identifying that this risk exists. You don't ignore it, and then you put contractual mitigants in place. Let's now move on to the regulatory considerations. What are the typical regulatory considerations that you would be concerned about? Every legal system, every jurisdiction has its own regulatory underpinnings. And for an acquisition in Nigeria, you cannot do this successfully without knowing what the Petroleum Act says about acquisitions. We start with the Petroleum Act. There are restrictions in assignment and transfers of OMLs, OPLs, and rights, power, or interest in these assets, type of assets. The law that the existing law expects that you engage the DPR at the early stages by notifying the DPR of the transaction and also procuring the ministerial consent to the transaction. Beyond that, we have the new kid on the block, which is the Federal Competition and Consumer Protection Act, that's the FCCPA. The commission in charge of this is quite, I don't know whether on the call, so I would not use the word aggressive, right? But they're quite active and they're trying to, to signal to the market that they're there to implement the provisions of the act. Basically, the law seeks to check activities in the industrial space that seeks to lessen competition in the market. For an asset acquisition, there's that debate that the FCCPA may not be applicable, particularly where that asset acquisition does not touch on the incidences of control, but it's arguable because you have FCCPC and FCCPA guidelines, which kind of suggest that any form of asset acquisition, as long as it meets certain thresholds in terms of control and the value of that asset, you would have to go to the FCCPC, that's the commission, to get your approval. If you are not sure, the law provides for negative clearance, so you still would have to have that engagement because it's too costly for you to ignore the FCCPC in today's world if you're engaging in acquisition in Nigeria. So you should bring this to the notice of your lenders. The question is always, when do we talk to FCCPC? Should we talk to them when we've identified the asset, we've identified the preferred bidder, or do we wait to actually secure the deal with that bidder and then we present this to the FCCPC? There are a number of rules on this. The FCCPC frowns on what we call gun jumping and any activity that suggests that you're already beginning to integrate with the buyer. As long as you're not at that stage, right, you're able to do as much as you can to at least secure your preferred bidder and have conversations around pricing. In September, which is quite recent, the DPR issued new guidelines on transfer of assets in the midstream and downstream sector. Okay, thanks. You've gotten the slide, so can you go to slide 8? Slide 8, please. Are you there? Hello? Hello?
Yeah, Miss, we can see you and we can see the slides now.
Okay, so please go to slide 8.
Wale, can you hear that? Okay.
Slide
good.
8, yes.
All right, she said.
Right, so I've discussed the price risk and the reason why it's important, and I was just discussing regulatory considerations. Touching on the latest guidelines issued by the DPR in September 2020. And what this seeks to do is to mirror what you have in the upstream sector for assignments and transfers of midstream and downstream assets. So any asset that has a license to operate, and if you have followed regulatory developments in the midstream downstream sector in the last 18 months, you would realize that you have a number of new guidelines regulating midstream activities and seeking to license midstream activities and downstream activities. Those licenses are issued in sequential phases. So you have the license to establish the assets, you have the approval to construct the assets, and you have the license to operate. Now, because hardly would you find an upstream divestment that doesn't have in that package some midstream facilities like maybe a gas processing facility, a gas conditioning facility. So you would have to have that conversation and check whether the guidelines are implicated in your deal. Why is this important? If you don't comply with regulatory considerations, it threatens the validity of your acquisition. And when you're lining up the conditions precedent to your to your transaction closing, that is the financing itself, or the conditions subsequent to your transaction closing, these points will feature. So you can't run away from them, which is why I say again that the starting point for you in this conversation can never be the loan agreement. You need to line up the ducks in a row before you get to the loan agreement itself. And then we move on to the contractual considerations. Except where it's a fresh bid round, right? Or it's a bid round for marginal fields or for open acreages. If it's any of the existing asset that has been divested by an existing operator or participating interest holder, typically, and it's not a sole risk asset, which is 100% owned by the producer, then typically you would have some constitutional documents that regulate and govern the relationship of the participating interest holders. The primary one is the joint operating agreement. And in the joint operating agreement, the traditional joint operating agreement would have restrictions on transfers and encumbrance, creation of encumbrances and transfers on joint assets. And for a second, you could ask me, I'm transferring my assets, so why would I be seeking the consent? I mean, the way the traditional GOA defines this asset, their concessions also come within the joint property. And that's the case because, we talk about undivided interest in the participating interest. So there's tenancy, there's common holding. And because of that, you need to seek the consent of the non-transferring holders, whether they want to preempt or whether they want to waive this right of preemption. If they don't waive the right of preemption, that means you have to offer to them. If you do not comply with the waiver provisions or offering to them first, it can be challenged in court. We have case law in Nigeria that speak to issues on non-compliance with preemption rights and consent requirements in jury agreements. I mean, yes, the two case law that we have are from the courts of first instance, could be overturned, but as we speak today, you still have to review those provisions when you want to make that decision whether to ignore this set of requirements. It has a greater, you pay greater attention to it when you're dealing with an SPDC, NNPC JV. If you're totally private parties, you can even just walk to that next party and deal with this. But when NNPC is involved in the acquisition, NNPC is a baby that you need to handle carefully, and you need to be sure that they are preempting before you can offer, before the seller can actually divest. So this consideration is important to the lenders as well. Next slide, please. And then we move on to social licensing. Social licensing, why is this important? If there is no social licensing, then you may not be able to operate peacefully. You wouldn't enjoy quiet possession. And this just unduly makes things difficult, particularly if you're in the Niger Delta. So the lenders are always keen to know what you have in place, particularly for existing assets. And then we move on to other consideration like the cost consideration. There is a consenting fees that you pay for ministerial consent. There are taxes that are important. There are assets that have existing liabilities like your flare penalties, royalties that are yet to be paid. And that goes to the question of good standing, checking for whether the guy that's divesting has done the needful. Why is this important? The lenders need to know their provisioning for this, how the warranties in the sale and purchase agreement will be structured to ensure that liabilities are allocated to who it should be allocated to. And this also goes to the question on existing liabilities. You could have contractual liabilities, non-contractual liabilities, abandonment cost, decommissioning cost. And if the new PIB is if the PIB is actually passed, there's going to be more focus on decommissioning liabilities, environmental remediation liabilities. They have to be provisioned for. And when you're drafting your sale and purchase agreement, these are the kind of considerations that the lenders will be checking to determine what exactly should be put in place in terms of the financing package. We then move on to the sources of financing. So what I've done in the last 30 minutes is to explain risk profiling, risk assessment, risk identification, even as you are selecting your asset. Once you've been able to tick your boxes and you're able to package that deal and make it attractive, a lender is willing to talk to you. So even if from day one, you have a big pocket as a buyer, at some point later on in the future, you may want to refinance, you may want to bring in private equity investors. So it's always nice from day one that you get it right. Governance level, operational level, the quality of the asset in question, social licensing, the cost profile, efficiencies, commercial prudence, all important in banking a deal. We then move on to the sources of financing. It could range from equity funding. As I said earlier, hardly would you find 100% equity funding for upstream asset development, to reserve-based funding, and I'm going to touch on each of these financing type in the next few slides, to forward sales, inventory monetization, and PFX financing. You also have corporate financing, and in recent times, we're beginning to see, infrastructure bonds, project bonds to finance acquisition of assets in the upstream sector. Now, let's move on to corporate finance. That's the next slide, slide 11, please. So for corporate financing, I should also warn and caution that in recent times, we're beginning to see, hybrid packages. So you may not necessarily find one clean, straight plan that is just a corporate finance. It could be a mix of corporate financing with a bit of project financing, or a bit of corporate, which is really leverage financing. It really depends on who is making the funds available, the status of the lender, the status of the financier, the status of the buyer, and the key considerations and the risk profiling. So for corporate financing, when we're corporate financing, we're lending to a business that has an operating track record and mature cash flows. So your real focus is not on that asset that you're financing. Yes, the asset must have its own, meet the necessary quality, but that's not the focus. It's this business has been in the market for a while. This company has got fantastic operating track record and mature cash flows. It has a very strong balance sheet. And in determining that balance sheet, you're looking at the financial statements, which have been prepared using international accounting principles. So it's balance sheet rich. That company is obviously investment grade. Maybe it's listed on a stock exchange or SEC regulated. And when you're listed or you're SEC regulated, there are transparency and accountability rules, governance rules that you must comply with, which makes it easier to deal with such entities, unlike a private company. And really, the focus here is that this business is a going concern, and you're focusing on the credit of that borrower, the spread of operations, and the cash flow. More often than not, the financing could be unsecured. Maybe you'd have a corporate guarantee somewhere guaranteeing the financing. And the tenor of the loan could range from 5 to 7 years. But as I said earlier on, we're beginning to see hybrid plans where it's not the traditional corporate finance, right? But when project financing is just infused into that mix, there's an attempt to ring fence the asset that is being financed. So if I were to break this down, you're lending to maybe any of the existing independent, your lending is maybe a seplat, good track record, mature cash flows, but then it's acquiring a brownfield asset. The lenders could decide that, yes, I'm looking at your balance sheet, but I'm also wanting to ring fence the asset you're acquiring, okay? So there'll be restrictions and covenants around that asset. There could be limited security on the asset itself. So I probably would not seek for you to grant security on all your assets. It would just be on that OML that you're bringing into the pool. You have arrangements like that. So it's always important for you to look beyond the labeling in any of these engagements and conversations. Speak to the lender. You need to know, what are you trying to achieve? What are the type of covenants, what the kind of ratios that you're putting in place? And then you'll be able to say to yourself, this is what we're doing. It's hybrid, or it's a straight plain vanilla corporate financing. And then you also have the leverage financing. Leverage financing is quite common in our market. It's the sister to corporate financing, but more complex capital structures. It's highly secured. So unlike corporate financing, where it may be totally unsecured, where it's investment, where the company's investment grade, right? Leverage financing is secured. Yes, you have your operating track record, you have your matured income streams, yeah? And the covenants are relatively light, but it will be secured. Then we move on to the pre-export financing. Pre-export financing, it would be rare to find this for greenfield asset. And I say so because it's not impossible, but the logic falls flat in the face of logic, because you're trying to capture the sales. So typically, the asset must have mature production profile. There's a minimum development risk. So they've developed, maybe what they're really financing is incremental production, okay? So the focus is on the sales and not reserves. Shorter term loan tenure, and the assets, you're ring fencing the asset, but you're focusing more on assigning the sale proceeds and the barrels that you're charging for the pre-export financing. So may not be common where it's a greenfield, or where it's an asset that you still need to go in and be sure of the reserve play before you make commitments. We then move on to reserve-based lending. As it suggests, the name suggests reserve-based lending. And here you're financing based on the borrowing asset base, which is the reserve itself. The lender's choice is to finance proven reserves. And when I say proven reserves that have 90% chance of recovery. And it could be a mix of, the P90 assets and P50. P50, i.e. 50% chance of recovery. So you could have an asset mix where P90 gives me that full assurance, and P50 is also thrown into the mix, particularly because it may not be a singular field. You could have a number of fields in the portfolio. And there is an assessment of the net present value of the cash flow from the oil production. You can diversify your risk across, as I said, across the fields. So you could have maybe a P90 field, a P50 field, you have it all in the same field, and you determine when you bring each field on stream. You need comprehensive security, because if it's against a reserve, obviously there'll be restrictions against the sale or disposal of those kind of assets. You also want to monitor production, because your lending is linked to the production profile. And more often than not, you tend to find that the lenders keep sweeping and sweeping. When there's excess cash, you sweep again to fund your debt service reserve account, just to ensure that at least we're lending against finite reserves. These are not renewable resources. So what you have in ground one day will no longer be commercially viable for you to exploit. So before you get to your reserve till, you want to ensure that at least you've recovered as much as you have. There's no lending institution in the world that is a charity. They're there to make money from the lending. So it has to be worth their while, which is why these considerations are important. Then we move on to project finance. Here for project financing, the real focus, right, is on the cash flow because it's totally off balance sheet financing. That's slide 15. It's totally off the balance sheet. You're focusing on the cash flow. Yeah, there are a number of restrictions on the cash flow, operation restrictions. It's, you know, the lender monitors the borrower. And there's also the debt equity ratio injection. So you must have a skin in the game as the borrower. And you know, those ratios we should typically range from 60 to 40 or 80 to 20 or 70 to 30. The higher hand in against the lender, the lower end will be the equity plus. The seasoned borrowers would insist on the project financing being of of no recourse to them. So if things go wrong, just go against the cash flow, not against the sponsors. But there are situations where, you know, there is insistence on having the project sponsor also put some form of security on the table. Typically, it's developed as a single asset startup with an SPV that has no track record. That's where the due diligence is quite extensive. You're due diligencing everything. It's a high risk venture because, you know, it's an SPV, it's got nothing. And the real strength is in the cash flow because you're looking at prolific assets. So you'd expect tight cash flow controls. You'd expect a comprehensive security package. The all asset debenture has everything, and everything is a kitchen sink approach. But I think the key takeaway, we haven't discussed all these financing types, is to know that there is no universal rule anywhere. A lender will look at the risk profile and will consider what it needs to do, the riskiness of the investment, and decide whether it's a hybrid or it's a plain one. And that's why, as a borrower's counsel, you need to understand the risk profile. You need to get your borrower ready. And it's always shameful if you have not engaged your borrower, who is your client, to be in this position. And it is when the lender then comes on and lender's counsel begins to identify, begins to red flag all the risk. And it's almost as if you're not competent. So it's important to always risk profile, red flag, amber flag, green flag, mitigate, identify, and then be ready for the deal. Once you've then identified the risk, and now you're plugging the risk and the source of financing, you can then decide it's time to document, right? And you have standard LMA type agreements that can be used, you know, to develop your financing arrangement. We'll then move on to the security package. You may be talking about security in relation to project documents, or it could be in relation to physical assets or the account. Now, for the project documents, what do I mean by the project document? It's always nice when you're in this kind of engagement, after you've demystified the component, plot that graph. Even if you've never done this before, if you plot the graph, you would have a sense of what is missing in your plot. So I'm acquiring a brownfield asset. They already have fields that have been developed. They already have processing facilities. There are agreements to evacuate and transport the hydrocarbons. There are agreements for terminaling and handling. You have offtake contract for the sale of the product. So you have a value chain, nothing is missing in your chain. Beautiful situation. It's a greenfield, there's nothing in place. So what do you put in place? Development itself, you need to drill, you need to develop, you need engineers, you need your EPC type contract and drilling contract to be able to drill your wells. You need your gas gathering or crude oil gathering lines. After gathering, you need to treat your crude oil. if you're just exporting, or if you're not exporting and you want to use locally, you treat. Now we have Dangote's refinery, and there are other refineries that hopefully would come up in the future, and also the rehabilitation of the Port Harcourt refinery going on. So you may want to treat in country and process. You need an agreement for that. Even after processing or whether you're treating, it has to be transported. It's either you're transporting using pipelines, or you're barging the volumes, the crude volumes. And if it is gas, you're transporting via pipelines. You need an agreement for that. Then also think about it. If you have product that you need to store, you need storage facilities and storage contract. So it's not rocket science. It's just really understanding, I have this, I need to take it from point A to point B. What do I need to put in place? Even that joint venture relationship, what binds us together? Our joint operating agreement. If we're not strong enough to be able to bring the operational skills to the table, what do we need? We engage field managers or we engage operators. So we may need a technical service agreement. It may be a field management service agreement. Speaking to the Schlumbergers of this world to bring in technical services. Okay. If it's a forward sale arrangement where you're forward selling your barrels, you would need your forward sale contracts. So what am I saying in essence? In filling this box that you have where you have the project documents, think about it, fill your box, and your lender may then be engaging you on the contract that they want assigned. Why do they want this contract assigned? They want it assigned because if things go wrong after you've stepped in, after they've disbursed funds to you, they want continuity, right? And they want to be able to also insist that whoever owes you obligations in those agreements can continue to deliver those obligations to their benefit. So it's either it's an assignment for benefit or it's innovation, a transfer because obligations are implicated. But I think the point to note is that it's not just a hard asset that you secure. You may also have to secure the project documents themselves. And depending on whose side you are in, you have to ensure that your suite of documents are complete. We then move on to the physical assets. And in the physical assets, you find your leases and licenses. Now, I don't want to get into that debate of leases are intangible, so why do you bring them within the realm of physical asset? I think the point you need to just note here is that, yeah, you have the right itself, which is intangible, but you have rights to go underground, in situ, and have assignments of the contract area. So the oil mining lease, the oil pipeline license, the project site itself, which is the land. And I mentioned earlier on that don't ever forget that it's not a given that the fact that you are going to have the right to exploit means you will not deal with issues relating to title to the land. If it's communal land, you need to engage, you need to compensate. The Constitution of the Federal Republic of Nigeria provides for compensation. You can't, compulsory acquisition has a process and protocol to follow through. For compensation. It's always in your interest, if it's a mining lease or a pipeline license, to buy the land. When you're talking about maybe gas plants, processing plants, and things you can immediately remove and assemble, disassemble, and move to other sites, there may be long leases may work for you, and then you decommission afterwards. And then we move on to the softer assets, which are the accounts. Within the financing package, you have several accounts. So let's walk through the accounts. For instance, the lender disburses to you. After it's disbursed, you would operate your asset and you would have revenue. Your revenue would typically go into your collections account. The lender wants to have oversight of that account. Now, where it's a corporate finance, this may not be one of the considerations, but where it's leverage financing, it could come up, and you have accounts security. There's the stamp duty reserves account, and when we talk about when we talk about stamping and up-stamping, we'll speak more about stamp duty reserve account. Insurances are important because it's a very risky space. So insurances, right from even development stage, your construction all risk insurance and all the other insurances, the lenders would insist on you setting up a proceeds account where insurance proceeds are paid into. If you have lenders offshore account is something you cannot overlook, because lenders are offshore and want to be able to enforce this account if they need to. You have your debt service account, you have your debt service reserve account, and your share and related investments account. Maybe you pay in dividends, distributions account into dividends. All of these assets may go into what we call an all asset debenture, or if land is implicated, maybe a mortgage over the land. There's no hard and fast rule. Please move on to slide 17. There's no hard and fast rule on the type of security, but over the years and traditionally, there's some security types that go with certain types of project financing. So, as I mentioned earlier, for corporate financing, you don't expect to find, assignment of all the project documents, assignment of EPC contracts. You probably won't find that. You may just find a corporate guarantee. But in a project financing where I'm really looking as a lender at the cash flow, then you have security over the accounts. You have security over the cash flow. You have even security over the OMLs, the OPLs, and that you typically would also find in the leverage financing, the reserve-based financing, where you're financing against the borrowing-based assets. You charge everything. The most important thing is to understand what it is that is being achieved. Also to understand if the borrower has existing obligations to some other lenders, and if for whatever reason it's not, they haven't created a security trust-based arrangement where there's a trustee that's holding on behalf of the existing lenders and other people can just accede to that pool. You need to have that consideration. And even from day one, even if it's just one lender, you may want to plan for the future by ensuring that it's not the lender that's holding directly, it is a trustee that is holding directly, so that you don't lose the benefits of the stamped amount after stamping. The next slide. There are other key considerations, ministerial consent. When we're dealing with upstream assets, it's been quite interesting in that space. Before we had the before we had the DPR guidelines regulating the transfer and assignment of interest in the upstream space and for oil pipeline licenses, it was very easy to argue that you would only have to seek ministerial consent where it's a direct transfer of the participating interest in the OPL or the OML, right? Or the marginal field license. But since the case of Monipolo and the issuance of the guidelines, it's a space where assignment means almost everything under the sun, a right in the OML, an interest in the OML, transfer of shares in the interest holder, even where you have all those layerings, i.e. you have a parent that is not sitting in Nigeria. So maybe let's take, for example, a Nigerian upstream entity who holds the OML directly is seeking to transfer not the OML itself, but its parent who sits maybe in Netherlands is seeking to transfer shares in that local company. Before the intervention of case law through a Monipolo, and the intervention of regulatory directives through the guidelines of the DPR. We could safely do this and just argue. Hello? Hello?
Yes, we can hear you, Sarah.
Okay.
Sorry,
okay.
let me see, we can hear you.
Okay, okay. So you could argue then that, you know what, I'm not transferring the OPL or the OML itself. But it's no longer the case. If you review the guidelines, assignment is broadly defined to in summary, cover any transaction that alters the incidence of ownership, alters the incidence of control, confers a benefit in one way or the other on the parties. So at every point in time when you have this conversation, you must always check, like literally opening the guidelines and checking each of those buckets. Do I fall within this or I don't? To be sure that you are not breaching the ministerial consent rules. It's also important to note that there is a fee implication for this. Under the current guidelines, there's a 5 to 10% fee implication, which is linked to the value of the transaction purse for the ministerial consent fees. For the midstream and downstream asset, as I mentioned earlier, you have a new set of guidelines. It's a bit confusing because if you look at the DPR guidelines for upstream asset and oil pipeline licenses, it already covers pipelines. But again, if you then look at the new DPR guidelines for downstream asset, it also has pipelines in there. Question is, maybe the intention is to capture petroleum products pipeline. But again, if you look at the Oil Pipelines Act, there is no differentiation between petroleum products pipeline or pipelines conveying crude oil. The Oil Pipelines Act, in my own view and interpretation, is that, you know, it's a piece of legislation that regulates the conveyance of hydrocarbons, whether petroleum products in its refined state or the crude oil itself. So they need to clear that. DPR needs to rectify that. But absent the controversy with pipelines, for handling facilities, processing facilities, storage tanks, there is that new consideration, and you have fee engagement as well. And then you also need to look at the timing of the consent and look at it this way. If a seller is, you're the seller, you're selling to a buyer. You're selling your asset to a buyer. And let's imagine your lender says, the lender to the buyer says, I'm not going to release the completion funds until there is ministerial consent. And the seller says, hang on a second, do you want me to follow you to the DPR and get consent without completion funds? How do we deal with this? And that's why typically in structuring the consideration, you would tend to find that for the completion funds, it's either the money is escrowed, so the seller has that confidence, has that assurance that, okay, there's money sitting in escrow, all I need to do is to comply and fulfill the terms and the requirements as a buyer and as a seller. There are other alternatives we've seen apart from funding an escrow account. It could be a letter of credit or a documentary receivable or documentary credit. And what are we trying to achieve here? Is just you really being able to evaluate that risk. There is a seller wanting to sell. A seller will not put in an application at the DPR to say sell to Mr. A without being sure, right, that there is a line of sight to day funds. Lender will not part with money without being sure that this will come through. So there is that structuring and that arrangement, which is why a letter of credit confirms that to you. Funds sitting in escrow would also confirm that to you. So it sits in there, and once we're able to go through this, funds are released. Consenting timing has improved greatly since the time of, I think, Kachuku. Yeah. So in recent times, we've been seeing consent being granted within 6 to 9 months of you submitting your application letter, unlike before where you had to project like 2 years, and within the 2 years, because of that projection, we had arrangements where the buyer then steps in as a technical and services provider, sits on the asset, begins to work the asset because it's committed to the asset, it's put in the application, has observer rights, but you don't really have to do that again because the time has reduced significantly. The World Bank negative pledge restrictions may necessarily not be applicable here because we're not dealing with NNPC type considerations. Repatriation of export proceeds under our laws for a producer of crude oil or gas, if your off-taker is offshore, the law doesn't say you cannot sell to an off-taker offshore. And the law doesn't say you cannot have monies paid to you offshore, but there's a rule for you to repatriate the export proceeds, bring it back in country, and that also has to be complied with. I've discussed the counterparty consent for the creation of security over your JV asset. It also must be considered. There are other considerations, please move on to the next slide. There are other considerations around stamping. I mean, why are we really stamping? Why do you have to stamp those documents after you've closed your deal successfully? It's important because it's the amount to which you stamp that you can actually enforce and realize security if things go wrong. So if your loan amount, so for instance, if your loan amount is X and you only stamp to the value of 10% of X, then if you're enforcing security, you can only realize the value to which you've stamped. But because stamping itself and the stamping rates are ad valorem, it's always a very difficult and emotional conversation. Emotional for the buyer because what if the lender never has to realize security? What if I do all I'm supposed to do? Why lose so much money ad valorem, at the ad valorem rate, you know, to the government? Let me stamp. And the conversation usually ranges between 5% to 10%. Let me stamp for about 5 to 10% of the up-stamping triggers. If we agree the up-stamping triggers, if they're triggered, I would then take steps to up-stamp. But the question around making payment for the up-stamping never goes away. So the money you never wanted to spend, you'd eventually spend it. What if you don't have it at that point in time when it becomes critical, like really, really critical to up-stamp? That's why you would find that lenders typically would put mitigants in place to deal with those kind of situations where there's a fully funded stamp duties reserve account. So what you're saying is, you know what, let there be a stopgap. I'm not remitting this funds to government yet, FIRS. No, I wouldn't do that. I'll keep it in a stamp duties reserve account. And if it becomes important, I will then do this. Lenders would also insist on having a negative pledge. These are negative covenants and restrictions that restrict a borrower from creating a situation where, you know, there would have to be loss of priority for the lender, or putting the lender in an awkward position where you go and then, create additional security for additional lenders and upstamp to the full value for them, you know. But it's always a conversation, and the risk appetite of the lenders would always determine whether we're staying at 10%, staying at 50%, or staying at 100%, going the full hog. Other security considerations have to do with local insurance. Our laws restrict assignment of local insurance policies to non-residents. It's fully restricted. So to deal with that, if you have local insurance policies, what the market is used to doing is appointing a Nigerian security trustee that can hold the policies on behalf of all the beneficiaries, or you could also have the several beneficiaries noted, as first loss pays in the policies. Or what you could have is have an insurance proceeds account. So from the insurance policy, if it materializes, payments are paid into the insurance proceeds account, and then security can be created over the insurance proceeds account for the benefit of the lenders. For reinsurances, there are restrictions, prohibition on assignment of reinsurances. And because of that as well, you have alternative arrangements in place, which could also be via your reinsurance proceeds account, and payments can be made into those reinsurance proceeds accounts. It's just that it's a stepped arrangement from the policy, right? The person that you can assign the policy to, it's assigned to. There is the account, payments can be made into the account, and the parties are eligible to take benefit of such account charge, take the benefit. You also have the National Collateral Registry. It's also a new development, and we're beginning to see parties comply with registration of security at the Collateral Registry. Registration is free for now, so there's no reason why one shouldn't comply with that. There are other considerations around lending and security sharing, and these are typically intercreditor considerations. So where you have a syndicate of lenders, or where you have lenders that have different rankings and ratings. So you have the senior lenders, you have the junior lenders, you could have subordinated lenders, mezzanine lenders, and different categories with different risk appetites and different priorities. When you have that, you need to engage and decide how ranking is done, how you deal with subordination, undertakings, voting mechanisms. And when I say voting mechanism, that's usually very you tend to have interesting conversations around voting mechanisms, because if I'm a majority lender and we have different lending profile to the same borrower, if the borrower defaults on maybe a tranche A or a facility A, but hasn't defaulted on another facility, you don't want that other lender to pull down the house at that point. When I say pull down the house, I don't want him to go and enforce security, because maybe we still have about 5, 6, 7 years to go on the financing, but it just so happens that there's a disgruntled lender. Do you then just bring down the house? So you typically will have consultations, voting mechanism, who can bring down the house, and if you must do that, what are the assets that you can enforce at that level? Can you cherry pick? Can you take the choice asset and just decide to enforce at that level? And even if you must enforce, how do we apply the proceeds? When we want to apply proceeds, if you have not defaulted against other classes of lenders, how do you apply proceeds at that level? So the considerations and conversations that lenders will typically have to ensure they're fully protected. And then we come to perfection. Having said all, you then need to perfect your interest as a lender. And brings us back to stamping. We've discussed stamping. The costs are prohibitive. They're quite prohibitive. So that's why there's always that conversation on should you be tempered. You should never go into a lending blindly without engaging and trying to at least secure the best for your borrower. And there's some, there's some very strong borrowers who would insist. They have a good profile. They're not known to default. Operational track record. So it's always very easy to have that conversation. So that's also why it's important that when you're advising, to be that trusted advisor, you're speaking to to the borrower who is your client on governance rules, transparency, accountability. Set yourself up in a way that you may be able to attract financing on that day that you need it. Then we move on to CAC registration. That's required within 90 days of the creation of security. Luckily, under the new CAMA dispensation, the fees have been reduced from 1% for private companies and 2% for public companies with 0.35% of the secured amount. So that's a fantastic development. And then for the notices, there's some security types, security assignment that require that you provide notice that the assignment has been created. So you send in the notice. Under the law, acknowledgement is not required. Acknowledgement is just for evidentiary value, to make it easy to be able to say, I notified Mr. A, Mr. A acknowledged. So there's evidentiary value that comes with that. If you're able to achieve that, fine. But does that invalidate an assignment if it's just the notification that is delivered and not an acknowledgement? No, it doesn't invalidate it. Other perfection requirements, if you're creating security over land, then you should get your governor's consent over the land. There's some states that have land registration instrument law, which means you also have to register your instrument. So typically when you're conducting your due diligence, which takes us back to the risk profiling, when you're conducting your due diligence on an OML or an OPL, for instance, after checking at the DPR, ownership of title and proof of title, and checking at the CAC, that's the Corporate Affairs Commission, for encumbrances on the asset, it's also important that you check the registry, the land registry, to see if there's any cautionary statement that's been filed in relation to those assets. Now, if your OML or your OPL happens to be an offshore title, you have a specific legislation that deals with that expects you to go to the registry of the state that is contiguous to your offshore asset. So we shouldn't make that mistake of saying because it's an offshore asset, the land registration law may not be implicated. You need to check your land registration instrument law to be sure that you've covered the field. And that brings us to the end of the presentation itself. Thank you.
Okay, thank you very much, EMC. So, good afternoon, everyone. My name is Untitled Chapter, and I'm the course coordinator for the NBA, CPD, and ICLE training. So, EMC, we're going to take questions now. And if you could just come back on. So I'm going to just read out the questions in the Q&A session, and then we can just go through the questions quickly. MC, are you there?
Yes, I am.
Okay, so I would like to see you.
Okay.
Okay.
Are you afraid I may run away?
Just for my comfort.
Maybe if I don't know the answer, I might just run away.
No, yeah, see, your reputation precedes you, so I'm sure you'll be fine.
Please go ahead.
Okay, so the first question, Ogenete Jerez and Baratu is asking is, what's a brownfield?
Okay, so a brownfield is a producing asset. It's not a green. You've developed the field and it's producing. So it's an asset that we are working the asset already. It's not a new field that's undeveloped. I don't know whether that answers your question.
I guess that answers Ogene and Baratu's question. So Nicholas is asking.
So it's just a nomenclature. Sorry, just a nomenclature in the upstream space that it's brown. It's not green because you've been working that asset.
Okay, so not green. Green. Once you say green, you know the opposite.
The land is green.
That
Yes,
makes sense.
Correct.
Okay, so Nicholas is asking, what are the efforts of governments in the implementation of the local content in the energy industry in comparison to IOCs in the production sharing contracts? Does that question make sense?
Okay, so
Yes.
it makes, well, I believe it does. I believe it does. And I think the perspective really is to understand that for the PSCs, except for maybe one or two, the PSCs are offshore, right? Now, all of the local contact acts, because I mean, PSC contractors are service providers, even though they're upstream producers in their own right and have their own assets where they have title to their concession, right? But in a PSC arrangement where the PSC provide, the production sharing contractor is a service provider offshore, what are the implications? What does the Local Content Act say about offshore services? If you look at the Local Content Act, onshore and swampy areas, there's exclusive consideration, which must be given to local indigenous companies. And indigenous companies are entities are Nigerian, right? And 51% of their equity shares are owned by Nigerians, right? But for the PSCs that are offshore, it's not, there's no problem with that because the exclusive consideration is for onshore and swampy areas. And it just then says that you should give first consideration, you know, to locals for offshore services. So if the perspective, if my understanding of your question is correct, there are efforts of government in the implementation of local content in the energy industry in the onshore and swampy areas, and it's becoming increasingly difficult, for foreigners to play onshore and in swampy areas. There are lots of arrangements that they get into to ensure that they are not, that they're able to compete favorably. But it's not a question, or it's not a challenge for the offshore and deep water play, because it's capital intensive, technical savvy solutions, which at this point in time, I mean, we can check, but how many, do you have locals? Do you really have our local companies offshore, in the deep offshore? You'd find the IOCs and the old, you know, because ultra deep play and deep offshore play is really their own turf. So there's no breach of that provision for now, to the best of my own knowledge. But onshore and swampy, take it from me, they're not, it's no longer a walk in the park for foreigners. It's getting increasingly difficult.
Okay, so Nicholas, I'm sure he's got that. So Charles is asked, so Obara is asking, at what point should the FCCPC be brought into a transaction?
Where's that question? So that's a
Obara.
That's $1 million question that I'm still being paid dollars for, but I'll answer your question. So there are, so in the FCCPA, which is the act itself, there's a suggestion that you should not do anything at all in relation to the acquisition without an approval of the merger or the acquisition. If you look at the code letters of that law, you get really jittery because you ask yourself, so do I go to the FCCPC even when I'm not sure that this is the bidder? This is my preferred bidder, particularly where it's not a bilateral, bid process, where you have a select few that you're speaking to as a seller. When you look at the code letters, what do I do? In fact, if you go further down in the act or in the regulations, it talks about standstill obligations, i.e., until you get that approval after notifying the FCCPC. Until you get the approval, you're not supposed to engage in information exchange, sharing of information, price sensitive information, you ask yourself, if I can't exchange commercially sensitive information, that means the bidder really cannot conduct a due diligence exercise on me. How will he confirm that he's interested in my deal, or vice versa? But luckily, the FCCPC issued gun jumping rules, what they call gun jumping rules, and they sought to clarify what they mean by standstill obligations. And I think the mischief, behind the gun jumping rules is really do not engage in any form of activity, or rather, you don't have to come to us as long as you have not engaged, or you're not beginning to engage in coordinated activities that would have an impact, on competition in the market. Do not begin to do things that would suggest that you're fusing the activities. As long as you're dealing separately, I can still see you, the two of you, as separate businesses. You're not fusing things together. You're not altering the pricing in your space. You're not substantially lessening competition. You can have those engagements. So I would say, if I'm opining, that you can conduct your due diligence, right, on the buyer or on the seller. You can exchange information. You can have conversations on the offer. You can get to a comfortable position where, this is my preferred bidder. This is the price range. And then I engage the FCCPC. But FCCPC then warns you that if you're not sure, come to me even at the early stages and let's have a conversation. The FCCP also talks about what you call the negative clearance. If you are in doubt, let's have a conversation. I think the risk really is that the FCCPC is new. Someone says they can't hear again. Am I muted? Can you hear me?
I can hear you, so I want to believe that everyone else can hear you.
I can too.
Okay, so that's fine. Okay, that's fine. Let me just go ahead. Thanks for confirming that. So you see, for me, there is a market, this is evolving market practice. They're new. There's a lot of market signaling going on. The number of new transactions that are closed that, FCCPC is talking to and, giving them, maybe I would say a tough time. So market practice in that space is evolving. So what's the prudent advice? If you know that your deal is caught within the ambit of their provisions. Okay, I've been asked to disable my audio and enable. So let me do that for the benefit of the people that can't hear me.
Okay.
And I would
Okay, so thank you.
let me do that, please.
Okay, disable and Constance said that. All right.
Hello? Is that okay now?
I
Better
can
now?
hear you. Yeah, I can hear you.
Okay, so let me just go ahead. So there's prudence, and there is a code letter of the law, and there is the guideline that helps. But what is the commission's disposition? The commission's disposition and the fact that the commission has the right to investigate ongoing matters and request that all documents relating to a transaction be made available, puts people under pressure. So you ask yourself, I know I'm going to have to report to these guys. I'm not hiding anything, as it were. So why not engage once you've identified your preferred bidder? And also ensure that, you're not making public announcement until you've engaged. And you see, this dovetails into the DPR guidelines as well. There's a point in DPR guidelines that's been ignored for such a long time, which is the provision in the concert guidelines that provide that there should be notifications to DPR before you take any step. In fact, the guidelines suggest that once you wake up and you have that idea, maybe at the management level or the board decision, you should really be running to them to say to them, I want to do this, because it says in selecting the process you want to use in selecting your bidders, the list of your bidders, they would also then, review and all of that. If it so happens tomorrow that the PIB is passed and there is that synergy between the Commission, FCCPC, and the DPR, then at the point at which you're going to the FCCPC, you're probably just going to the DPR, and it will be the early stages. But if, for me, if there's nothing to hide, and you already know what you're doing, and you've lined up your ducks in a row with a bilateral bidder, then once you confirm that this is the guy I'm going with, and you've done your price discovery, I think you should inform them. But if in doubt, or your lenders have very huge, if they're risk averse, then you should be seeking clarification from day one.
Okay, so I guess it's just that question of,
Does that help?
Yes, it does. Yes, I'm sure it does help, Obara. And I totally understand that, people don't like to involve government until they really need to. So I guess it's from that. So William is asking, is it not always prudent to secure financing of a project in principle before seeking regulatory approval, rather than seeking regulatory approval before seeking financing, particularly when regulators would also want to know your financial position?
Okay, so it's an egg and it's a chicken and egg situation, and I think I covered that. So when you say secure financing, that's a vague expression. If I have a letter of commitment from a bank today to say I'll fund you, have I secured financing? Right? I don't know whether that's what you're securing financing. Or securing financing could be that I have executed the loan agreement. We've agreed our conditions, both the conditions to draw down and the conditions subsequent, one of which would be the regulatory approval. I then take steps to seek regulatory approval. So if your reference to securing financing refers to when I have just that commitment, then you can be seeking regulatory approval at that stage. You should be seeking regulatory approval when you've baked that deal, you have your loan agreement, you've executed your loan agreement, you have clear line of sight to the financing. Then you then take steps to seek approval. Now, the point that may be a bit confusing maybe was when I said the lender wants approval, the seller wants money, and seller says, if I don't see money, I'm not going to put in an application for approval. And the lender says, I can't release money without approval. And that's the point where I said, you have to put instruments in place. So look at it this way. The critical agreement, you have the sale and purchase agreement, which is that agreement that is selling the asset, right? You then have your financing agreement. We should not confuse the two, because if you have a very deep pocket, you may not need the second one. It's just the purchase agreement, and you sell, you pay money, and you move on, right? But in a situation where you have the two, you need the lenders and you have the purchase agreement. Purchaser says, the seller says, I have this to sell. There are conditions to this transaction closing. Conditions include you having ministerial consent, because if there's no ministerial consent, I wouldn't have sold to you, which means I would not, as a buyer, pay until there's ministerial consent. You get that? We then move on to the lenders in your lending agreement, where I would release the monies as long as you have regulatory approval. That's why if you have documentary credit, like a letter of credit shows there is money. Seller, there is money. Look at it. It's bankable. It's a third-party issued letter of credit. You can bank on it. It is as good as cash. Go and apply for ministerial consent. Once ministerial consent comes through, for escrow arrangement, letters of credit, you have your independent drawing mechanism. The monies are not they're sitting with a neutral party. So you're able to turn on the tap and the monies are released. So it works together. But you can't, if you have not secured financing, you shouldn't be seeking regulatory approval.
Okay, that makes sense.
Yeah.
So Jeremy's asking, please, can you talk about the concept of industry hold harmless and if it is being practiced in the Nigerian oil and gas sector? I guess you understand that.
Okay, so industry hold harmless. I believe
because we have a misrepresentation act.
Sorry, go ahead. It's to me.
Okay, so the industry hold harmless provisions. You have your what we typically in the industry refer to as the knock for knock indemnity provisions. So it's either you have the hold harmless or you have, which is what we call the knock for knock. And if this person is still on the call, if you're not talking about knock for knock, please, you can still revise your question. So you have your knock for knock provisions and you have your guilty party pays principle, right? Now for the knock for knock, which is a hold harmless, best understood where you have maybe the producing asset, the operator here, and you have maybe a midstream facility. I just want to use it to amplify the risk. So, or maybe a service provider. Yes, let's use a service provider that is rendering services to an upstream producer. The service provider brings in his assets, equipment, his personnel to that field. The upstream producer, within its own field, its own battery limit, has things in place as its operations, right? And maybe there's an EPC contract or some contract with interparties between the two of them. And the upstream producer and the drilling and the service provider then agree that, you know, when it comes to injury to persons, damage to property, pollution, death of personnel, let's agree to hold each other harmless, irrespective of who is responsible for that act. It sounds crazy because what you're saying is, I as the producer, the service provider comes within my battery limit, right? Causes harm within my battery limit, right? To my personnel. But I say I'm holding you harmless. In other words, I won't hold you responsible for that. I would sort it out. So that if I also do the same, if I come within your space, maybe I harm your personnel or your property is endangered or there's death of your personnel, injury or whatever, I'm also saying, the service provider is also saying to me, you know what, I hold you harmless. And that's why it says knock for knock. You're knocking one against the other. And why is that so? It's always said that, you know, the producer or whoever it is in that space is in the best position to rectify and deal with the harm. You know the process you already have in place if your property is damaged, right? You have your HSC principles, you have your remediation plan, you have your compensation packages for your employees, right? So if things happen, even though caused by the service provider or the other party or counterparty, I'm in the best position to fix it, so I'll deal with it. If it happens to you too, even though I caused it, you're in the best position because you have your operations. And you know the way in the upstream sector, and then even across the chain, they're very, very careful about people coming within their battery limit to fix things, to operate. And I guess that's one of the reasons why the gas flare commercialization program hasn't worked, because you're inviting third parties to come and be doing stuff within producers' battery limit. You get what I mean? So they're very, very careful because when things go wrong, it's really terrible, right? So the question then is always, okay, if I'm allocating this liability and it's knock for knock, hold me harmless. Should I hold you harmless even when you're negligent? Should I hold you harmless even where you're just, there's willful misconduct? And, you know, it turns on negotiations and conversations. And some would say, you know what, hold me harmless in all situations. So when it happens, you deal and I deal. But the flip side is the guilty party pays allocation of indemnities. And when you're allocating that, what the conversation really is, you know what? If I'm not sure, you know, there are situations where I know that there's just so little, I'm so efficient at my operations, there's just so little I would do to damage you, but I'm not sure of your own operations. So do I want to take on the knock for knock or the hold harmless? I say, you know what, let the guilty party pay for losses. And then there's also the treatment for third party liability. So it's common. And if you're new to the game, you get upset. You're like, you know what, why are we knocking it for whatever? Let the guilty party pays, but they're used to it in the industry. That's how they deal. Next point, next question.
All right, so we have just about 17 minutes, so I'm hoping that we can take at least 5 questions. So, Yemisi, please, could you just tell us quickly, Abiodun is asking how long it takes to get ministerial consent to take security?
Ministerial consent to take security. People avoid it, and that's a starting point. And that's why you would find that for upstream acquisition, the financing package avoids a mortgage, avoids a fixed charge over the concession and charges, because the argument is that if it's a floating charge over the concession, you have not created quote unquote proprietary interest that requires consent at creation. They will go for consent at enforcement, right? I don't know whether that differentiation is clear. So there is ministerial consent for the acquisition itself, which is typically between 6 to 9 months, depending on your relationship and who you're engaging. But ministerial consent for security, in all the ones that I have been involved in, we've avoided having to go. And you've toyed with, you know, you've been creative in the security package such that you don't really have to go until you have to enforce and not at creation.
Okay, so that makes sense to do.
But under the new, if the PIB is passed, whether it's a fixed or it's a floating or it's a crawling charge, you have to go. Yes.
Okay. All right. So Kazim is asking, what's the difference between alternative funding arrangements and project finance? So I would want you to take Akaniene's question, which is also the difference between upstream, midstream, and downstream assets. So if you can take those two together, because we're really running out of time.
Okay. So let me start with your upstream, midstream assets. So upstream, it's very clear. And I think it's on the, second slide. Exploration activities, drilling, developing your upstream assets, the fields, the wells, that's what you're doing, right, at the upstream level. People will tend to say to you that treatment of the crude oil is also part of the upstream upstream activity. So you're doing everything within which space? The upstream development, trying to win the crude oil. Right? It's in the subsurface soil, right? You're trying to win that crude oil and everything that you need to bring out the raw crude to the surface is that upstream activity. Or for your gas as well, because you could have non-associated gas fields where you're not even talking about crude oil development at all. It is the NAG that you're developing. So you drill. So when you talk about engineers that are drilling, they are drilling the wells, they are drilling the field, they have a field development plan, concept studies around drilling. It is about, I want to win the crude oil, right? And everything that happens up onto your flow station, yeah, it's upstream. You then have the midstream space. And I would invite you to check the elaborate definition in the PIB. The latest PIB draft has such a beautiful, well, let me not say beautiful, let me not opine on it, but expansive definition of midstream. And it suggests that everything after your flow station, after the gas gathering lines, you're trying to process and put the crude oil, the hydrocarbons, which will be crude oil or the gas, in a marketable state. So you're processing it, you're refining, you're transporting. So your gas transportation pipeline is a midstream asset. Your gas processing plant, your gas conditioning plant, your refining asset. I mean, some would say your refinery is a downstream asset, but I beg to disagree with that. But anything that you do to be able to put the crude oil or the gas that you've won in a marketable state and to transport it comes within your midstream space. And then when you move on to distribution, storage, you have your storage tanks, you have your, like a terminal, you store on your terminal. Then people that distribute petroleum products for the downstream is real petroleum products distribution. That's what you do in the downstream sector, product distribution. So petroleum products pipeline would be in the downstream facilities, storage tanks, tank farms, downstream. So it's for you to look at that chain and then put your lines and just make sure at least if I'm not fitting it within the upstream, it's in the midstream or in the downstream. It's somewhere across that line. But if it's crude oil, it is upstream. It's an upstream activity. And now let's move on to alternative financing. And I think you said project financing. So for alternative financing means alternative financing, which is something we've seen in the last few years with NMPC, where they've switched to what they call the forward sale arrangement for incremental production. What are they trying to do there? So when we say alternative financing, I can structure an alternative financing, but end up looking at the cash flow, which is what project financing looks at. But if it's alternative financing based on what's going on in the market, you have about 2-3 deals that we've had in the recent past where there's been a switch because of the issues with joint venture cash call obligations, all the restraints and restrictions, and the issues that NMPC has had in the past, being able to borrow, being able to create security rights assets. Then this new method was developed where there is a forward sale of the barrels before they're even produced, right? So in that case, I am selling my production before I produce, selling forward. If I sell forward, I get a deposit from the entity that has been sold to, which is the financing, right? And that the deposit is enough to carry the project through the development of the incremental production. Now, the way it's typically structured is, you have that your SPV, that orphan SPV that the forward sale barrels are sold to. That orphan SPV, because that orphan SPV can create security rights assets, can go into the market and borrow and lend against the crude proceeds that is forward bought, if there's any word along those lines. But I think the most important thing for you to notice, if you see alternative financing in a non-Nigerian audience, alternative financing means alternative financing. It's an alternative to financing, and typically you're looking at forward sale arrangement, you're looking at like your PFX that I spoke about, where you're focusing on matured assets and the sales. We are looking at export finance proceeds. So another way to answer your question to say, alternative will focus on the sales and the barrels are being sold, whereas my project financing is just that SPV focusing on cash flow, and the strength of that deal is the cash flow.
Okay, so Thank you very. I think we'll be able to take one or two more questions before Dr. Ni, who is the head of the faculty, will be able to round off for us. Dr. Ni, if you're there, please just stand by. I think this should be maybe, let's see how, if we can take two, but let's see one. So Akko is asking, how does a borrower deal with delays in the acquisition of regulatory documents? For instance, you just mentioned that ministerial consent takes around 9 months. What does this tell the lender, and can this affect the borrower from getting the loan?
So the market is used to it, right? And don't forget that you haven't parted with, if there's no regulatory consent, you haven't parted with your asset as the seller. You haven't. You've just indicated that you intend to part with your asset. And whilst you're waiting for regulatory consent, you're still working your asset. That's number one. Number two, the lender has not released money. They've executed. There's a long stop date. There's a window within which the consent should be obtained, right? So it's planned for. Okay. Now, there is the question around material adverse events. We could change the pricing or the value of the asset. And in some cases, you could have adjustment factors. So if that's what you're talking about, how do you deal with delays? I haven't bought it as a borrower, but I conducted due diligence on the 1st of January. And I've seen an asset that is prolific, that can deliver 10 barrels a day. And there's a 9 months gap. We're talking about finite resources. And within that 9 months, what if the lender just increases aggressively production and begins to just deplete resources? What does the borrower do? That's why in those kind of sale and purchase agreements, the ones that are properly done, you tend to find material adverse event provisions. You find adjustment provisions that allow you to adjust the price if there are leakages during that period. And leakage could be in the value of the asset. Leakage could be in depletion of resources. Leakage could be in the fact that maybe the seller is trying to run down the asset. But the most important thing I think to know is that nobody has parted with anything in terms of the asset in question, even though borrower has committed himself. But the market is used to that, and they're able to deal with six months to 9 months.
Okay, so this is going to be the last question, and then I would, and Yemisi, you also answer my own question. I'm an IP expert, so I know sitting in a big law firm, I know I have, people on your end who are on this transaction that takes sometimes years. I keep hearing one transaction, years. So in your experience, what has been the longest time an oil and gas transaction has taken? That's my question, which you answer. And so Ubogo is asking, please, what is your view on setting up clean teams at the early stages? Will the sharing of sensitive information within the clean teams breach FCCPC guidelines? Then after that, Dr. Ni will say thank yous. And okay, Tobena is back. And yes, over to you, Yancy. Please, you have to answer my question. Your longest question.
Well, the longest have been, there was one that from 2017 and only just closed in 2021. And I know that the deal, I know that even the preliminaries started as far back as 2014.
Wow.
But where the assets, there's always a political angle to these things, right? There are simple assets that you can acquire and parties move on. There are assets that there's a lot of Malibu, for instance, OPL 245. Anybody that wants to acquire Malibu, it's going to be in it for a long time. I did a due diligence on Malibu in 2017. That spanned maybe like 18 months. It was never purchased. You can imagine due diligence spanning 18 months.
So how does lawyers make money? Because you want to get on this deal, finish it, and move on. So I'm asking someone wants to make it.
That's why we are begging our clients to keep paying so that our lawyers don't run to the industry. They stay with law firms.
Okay, so the question on teams, please.
Okay, so are clean team agreements practicable in Nigeria? With the sharing of sensitive information with the clean teams bridge FCCP. You see, I took my time on the FCCPC guidelines that you have gun jumping rules, you have provisions in there. The mischief for me is they're trying to avoid a situation where you begin to have coordination between the two entities. So before you go to FCCPC, there must not be any form of integration at all. So if you like, have a clean team, have a brown team, have Chinese walls, have ethical walls, have whatever teams you put in place. If coordination, integration is detected, because it's really about the impact. So if, for instance, the market knows, for instance, that Coca-Cola is merging with Pepsi, and it begins to alter pricing, alter things in the market, there's a problem already. That activity is beginning to have an impact in the market. So there are times that it's even the announcement that causes the problem. I don't think at this stage, anybody that it was not part of the drafting of the FCCP or does not sit in FCCPC can say to you categorically that please do this and don't talk to them. Me as MEC, any deal I'm on, you have to be very careful with announcements, careful with information exchange, materials exchange, and speak to FCCPC once you know what you're doing. So you need to opine with caution.
Okay, so thank you, Yamisi. Is Dr. Oni available, or Tobina, will you take over from here?
I'm available, but I don't know if Tobina wants to.
Yeah, say something. I'll conclude quickly.
Okay, thank you very much, Yamisi. Very interesting. I did learn quite a bit, and I always learn from you. Yeah, my Egbo. It's been an excellent presentation, and I guess there were several questions that were not answered because of time. And for people to be disengaging, then it must really have been interesting. You're shining light. So your reputation precedes you. So we're very grateful. We will call on you again, and we do believe that you will respond. I know when I first told you, it was very short notice until we had to move things around, and you were a bit upset with me because you expected to be more. Yeah. So I still thank you nonetheless for taking out time from your very, very busy schedule. I know how busy you guys are, and you in particular. Thank you very much, and we look forward to having more engagements with you. Over to Bena.
Yeah, so Ayo, thank you very much. Yemisi, brilliant presentation. I enjoyed it myself. I had to go for a bit, but the much I heard was very illuminating. And I think that the presentation style was very clear, very simple. And I'm sure for you to have gotten interested in energy law and policy, that takes a lot. So congratulations. I look forward to listening to you once again tomorrow. And I thank everyone else who's been part of this, Dr. Yaliloni, Nte Biken, Sarah Jijola, and all the delegates who attended, and the rest of the energy law and policy faculty of the Institute. I thank you all for your time and for all that you do for the growth of our profession. Thank you very much, and God bless you all.
Thank you very much, everyone. It's a privilege. Thank you so much. Thank you. See you tomorrow.